the products, maybe have manufacturers, if they're going to do testing, report those results, or maybe even require testing. Speaking of, we do have a new testing bill in Arizona for marijuana, and it passed. But this is going to all unfold in front of our very eyes over the next few years. I surmise we first have to cycle through the current presidential administration and get on the other side of it. But I think once we're there, this is all going to come to a fore, and a solution that is sensible and reasonable will emerge from it.
I think you're right about that. And yeah, I look forward to that day, to be honest. It's pretty frustrating. I was just in Washington, D.C. for the first cannabis caucus to be held at the U.S. Capitol building, and had an opportunity to speak with a lot of the Congress people who are supporting some of these bills. And there seems to be some pretty heavyweight support for this. And when you consider that a lot of very, very conservative people are now on board with the cannabis movement, like, for instance, the former Speaker of the House, John Boehner, is now in the cannabis industry himself and advocating for it, along with all of the rest of us who would really like to see this movement succeed. So I just hope that the federal agencies will get out of the way. And it's pretty insane. So what else is coming down the pike legally that we should know about? I know that there's the recent legislation that's going to correct some things in the Arizona legislature, but what about any legal cases pending that might affect the industry?
Industry-wide. Rob, what do you think?
Right now, the only case I've heard that might be percolating up is one that involves whether an individual patient, whether the immunity that the Act provides for the manufacture of medical marijuana products extends to the patient, him or herself, such that, making something at home, for example, is whether the question is whether that would be immune. I think that this decision actually answers that question, the Jones decision. I think the court makes it very clear by going to the definition of medical use and pointing out the term manufacture, that patients, caregivers, and all other participants of the industry can manufacture products made with extract. So, but I can see that issue percolating up, and I've heard through the grapevine that it might do so pretty soon. And
we won the dispensary brownie rights. Now we have to win the home brownie rights.
Right. But we're ready. I welcome the next challenging cannabis case that needs to go up on appeal, because one of the nice byproducts of handling a case where you have to absorb yourself in an entirely new industry and entirely new subject matter is that you become an expert in it. And so we're totally ready for the next one.
And that's a good point too about the home remedies, because there are a number of patients who like to just prepare their own tinctures.
Of course, and indeed every patient is preparing their own extract, because at the end of the day, you're extracting the resin by smoking it, you're extracting the resin by employing any of the other methods that are used to create these products. You're always extracting the resin. And if you're not extracting the resin, you're not consuming the medicinal component of the plant. So you're kind of wasting your time. And so it's sort of an absurd distinction. And that's what the voters intended this act to do, was to bring the medicine to the patients without their having to fear state criminal prosecution. So it seems to me like the answer to these questions is very clear. The act immunizes it.
Yeah, or it should. And the prosecutors should realize that. Voter intent is so important, and that's why it was so counterintuitive that Rodney Jones lost his appeal. It made no sense to me.
Yeah, another thing, Snowden, that might come to the fore in the next year or two, if you read the Medical Marijuana Act statutes, there's a prohibition against public smoking. So I can't be sitting on a public bus and just light up a joint. But the word smoke is what literally appears in the text of the statute. What about vaping? That's technically not smoke. It's definitionally not smoke. But nobody yet that I'm aware of has been arrested, tried, and convicted for vaping in public. But I rather suspect we're going to see that case come up in the next 12 months. I wouldn't be shocked.
That's a good point. I can see that easily happening.
Mm-hmm.
And I think that a literal interpretation of the act immunizes vaping in public. And so I can see that issue coming up for sure in another attempt by prosecutors to limit the scope of the act's protections. So stay tuned for that for sure. Yeah. Another interesting, a little bit deeper in the weeds, no pun intended, is that people need to recognize that the immunity that the act confers is not just an immunity from prosecution, but it's an immunity from arrest. And so indeed, what this act really means is that somebody who has a medical marijuana card, I'm speaking just to the patients at this point, cannot even be arrested. And that is not something I believe the police or the prosecutors are actually honoring in the act itself. And I can see a case arising about whether or not the arrest of a patient in and of itself is a violation of the act. That's what I'd like to handle, because I think that you have to take the act by its plain terms, and it clearly does not merely immunize prosecution and incarceration. It also immunizes you from an arrest. I think that's a very important point that will come up soon.
Yeah.
If you've never had the exciting pleasure of being arrested, which I haven't, so I'm not speaking from experience, but I do understand it's not pleasant.
How do you make it up to someone who spent 2.5 years in jail and has had to go see a parole officer or whatever he's had to do for the rest of the time and go through the expense of a trial like this? I mean, how do you make it up to someone for such an egregious, it seems like an abusive prosecution? And especially if you do go back and you look at the voter intent of passing this measure and the protections that act should have provided to him, but ultimately failed to provide to him. So I wonder if there will be any reparations for him now that he's succeeded in the final Supreme Court decision here.
This is Gary. I'll let Rob answer that because Rodney is Rob's client. But I will say, as preface, how do you give somebody 2.5 years of their life back? Assuming any remedies available, how does somebody get more time? I'm not aware of a method to solve that.
Yeah, exactly. I mean, it's priceless. You can't replace it. It's gone. So, Rob, what do you think?
Well, what I can say at this point is that no decisions have been made, but the question you're posing is being reviewed. And I'll point out that just the one thing that I can say at this point is that there is a United States Supreme Court case of recent vintage that holds that the state is responsible for reimbursing all expenses. In other words, any restitution, fees, or fine that a defendant who has been exonerated incurred as a result of the conviction. So there is U.S. Supreme Court precedent for getting those types of things refunded. And all I can say at this point is stay tuned for more news.
Well, I look forward to hearing about that. And God bless Rodney Jones.
Yeah. We're still absorbing the opinion.
Yeah, I mean, we're still in week one, and
exactly.
It's a nice day to be alive.
Yeah. Well, I can only imagine how emotionally impactful that decision was for Rodney Jones in a good way. But at the same time, it's so bittersweet. It's like, well, see, I told you so. I should never have been incarcerated, and sure, I'd love to speak with him at some point on or off the record just to hear his thoughts on this. So let me know if he's ever willing to, even just provide a quote for an article, because this is just such an important issue. And it's part and parcel of just solving, this mass incarceration problem that we have. But I'd love to hear from him at some point if he's ever willing to speak with me about this. And I'd actually love to have him on the show. So please, let him know that.
We will certainly let him know.
Oh,
sure.
So I'm getting a signal that we need to start wrapping this up. But is there anything else that either of you would like to let our audiences know? Rob, let's start with you.
All I want to say really is I want to extend a huge thank you to the community for all of the support of our efforts to obtain justice for Rodney. I mean, everybody in all segments of the industry have been so supportive, as well as, of course, the patient population. So we're just delighted we were able to do something good for Arizona and for those who need these medicines. We're there for you if you need us.
Well, thank you for that. It was absolutely a sweet victory. And yeah, Gary, what do you think?
Yeah, absolutely. So my parting thoughts are this. It's not often in a lawyer's career that we get to take on cases that impact huge populations. In this instance, this case affected literally every Arizonan, whether or not you were participating in AMA. That doesn't happen a lot. So I feel really lucky and blessed to have had the opportunity to be on the case and to do some public good. So that's just a nice shot in the arm for my own little ego. Lessons I hope people take away from this. One, don't forget that Rodney Jones sat in a jail for 2.5 years for a crime he never committed. I know that message gets lost a lot, and it irks me to no end. Rodney genuinely suffered. He shouldn't have been in that position, and it wasn't his fault. So I hope everybody remembers Rodney. That's point number one. Point number two is the Supreme Court taught everybody an important civics lesson in this case, and I hope that doesn't get lost on the population either. The Supreme Court took to heart quite seriously the notions of justice that go behind not merely the charge in Rodney's case, but more importantly, the will of the voters, because the Medical Marijuana Act exists by virtue of a proposition. It's Proposition 203. This didn't originate in our legislature. And the Supreme Court could have, done something other than what they did. But they ruled appropriately, and their opinion tells us quite clearly they looked very hard at what did the voters ask for when they voted for this, because they're entitled to get what they voted for. And the Supreme Court held that. And that's critical. And of course, that leads to my final and third point, which is this. The ability to enjoy or participate in any aspect of medical marijuana right now isn't born by virtue of any rights that you can go to the U.S. Constitution and pull out and point at, although you should. And oh, by the way, the Constitution is printed on hemp paper. These are privileges that come to us by virtue of our enactment of our own statutes. We're a nation that is designed and built upon a sense of self-regulation. We don't have kings, we don't have monarchs, we don't have despots. We're a people that rule ourselves. And we have to be open-minded and willing to listen and be smart about how we establish policy and what the reasons are behind it and how we effectuate it. And we have an opportunity staring us in the face to open up a whole new generation to a whole new way of thinking in a much better way that's kinder to one another, that's gentler to one another, and embraces all the things that make the United States great.
Very good points. Yeah, very good points. It's really interesting. If people haven't read the Constitution, actually, the repeal of prohibition, Amendment 21, actually made it a right to consume alcohol. And I often wonder if a repeal of prohibition isn't necessary in Congress, and it's something that I'd like to push for eventually. And if there ever is a constitutional convention, I think that this is an issue that should be addressed. And, It's a plant. We have the right to consume vitamin C, so why shouldn't we have the right to consume another molecule that's absolutely harmless?